Hello, and thank you so much for joining me today. I'm Vangela M. Wade, the President and CEO of the Mississippi Center for Justice, a nonprofit public interest law firm committed to advancing racial, economic, and social justice. The scope of our work is far reaching. We have lawyers and advocates dedicated to consumer protection and fair housing, immigration, health and public benefits, and disaster recovery. Our George Riley Impact Litigation Initiative focuses on voting and election rights, reproductive rights, criminal justice reform, and discrimination. Today, I am so very honored and thrilled to be joined by former Solicitor General Donald B. Verrilli Jr., a partner with Munger, Tolles and Olson, and the founder of its Washington, D.C. office. Dunn is a very active member of our board of directors here at MCJ, and he was the honoree last summer at our Mississippi on the Potomac event. We're so honored to have him back so soon because he is one of the rare titans of our legal profession who listens more than he talks, who cares about the issues and the people that he fights for more than you or I knowing about his role. And Don is a very valued and frequent contributor of ideas and direction and guidance for our work here at MCJ. He continues to demonstrate his commitment to justice through his pro bono work for MCJ and has played an important role in MCJ's challenges to two very notorious provisions of Mississippi's law. The first was the anti-LGBT legislation known as House Bill or HB 1523 that was passed in 2016 after the Fifth Circuit reversed the district court's injunction blocking that law for a year. Dunn led a very valiant effort to persuade the Supreme Court to take the case and restore that injunction. Unfortunately, the court did not, but not to be deterred from fighting discriminatory laws and systemic injustice, John has joined us once again to lead the appeal in our challenge to the felon disenfranchisement provision of Mississippi's 1890 Constitution. The panel just ruled against us based on an adverse precedent in 1998, and Dunn is gearing up for the en banc petition and the likely petition to the Supreme Court after that. So he's ever vigilant. Our pro bono team, I will add, on that case also includes Fred Banks, Armin Durkner, and our board member, David Lippman, all legends of Mississippi civil rights law. So Don, thank you again for joining us today. And jump right, let's just jump right into it. I want to hear your perspective, first of all, on the most important cases currently before the court, your recent work helping to protect the integrity of the 2020 election, and your experiences before the Supreme Court, including your most compelling cases as Solicitor General in the Obama administration. And I know that it's going to be difficult for us to pack that into an hour, but let's just start with the Voting Rights Act that was recently put before the court, at least Section 2 challenge that was really recently put before the court during this week. What can you tell us the importance and the implication of this case?
Well, let me start, Vangela, by thanking you for inviting me to have this wonderful conversation and for that extremely gracious and frankly way over the top introduction. It was really nice of you. You know, I consider the opportunity to serve the Mississippi Center for Justice and work with my amazing lawyer colleagues on the matters you described as a privilege. I'm very grateful for the chance to do it. And moving on to the topic at hand, I think it probably does make sense to start with the Voting Rights Act case that was argued before the Supreme Court just 2 days ago. It's a case coming out of Arizona about Section 2 of the Voting Rights Act, which of course has assumed even more importance in protecting the integrity of the right to vote and protecting against discrimination and the right to vote in the wake of the 2013 decision by the Supreme Court in Shelby County to declare the preclearance regime under Section 5 unconstitutional. So the issue that came before the court this week is actually a really important one, and one I think is going to assume increasing importance in light of all of the voter suppression efforts that are being contemplated by a number of states. And most cases that people are familiar with under Section 2 of the Voting Rights Act are cases about redistricting. Now, what Section 2 does, of course, is impose something that's come to be known as the results test. It basically says that the denial or abridgment of any state action that results in the denial or abridgment of the right to vote on account of race violates Section 2. And in the redistricting context, that's come up typically in vote dilution kinds of cases of the sort that the center has been involved in, and that our wonderful colleague Rob McDuff has litigated many of and continues to litigate many of. But in recent years in particular, it's also come up with increasing frequency to challenge different kinds of efforts to deny or abridge the right to vote of protected classes under the statute. And that's what, and that is in such measures as were at issue in Arizona. Two measures in particular. One which said that if you vote in the wrong precinct in Arizona, that your ballot gets thrown out, doesn't count. Even the votes you cast for statewide office or national office, your ballot gets thrown out. And the other was a provision of Arizona law that made it unlawful for anyone to assist in the in mail-in and in the casting of mail-in ballots by collecting mail-in ballots for others and then delivering them to the post office to be mailed in, or to the electoral officials to be mailed in. And that had a particular effect on Indian reservations in Arizona, where people are very significantly distanced from post offices, and those who are elderly or infirm or disabilities in particular tend to rely on these others to gather their ballots up and take them to the post office and mail. So the challenge was brought successfully in the lower courts to those provisions under Section 2 on the ground that they had a disparate effect on the voting opportunities of Latinos, of Native Americans, and African Americans in Arizona. And the question as it came to the Supreme Court is, well, how robust a protection is Section 2 of the Voting Rights Act going to provide in cases like these, where you're not talking about challenges to redistricting district lines, but you're talking about challenges to these particular practices. And the state of Arizona and the Republican Party advanced what, at least from my perspective, is quite a radical proposition, which is that any facially neutral, what they call time, place, and manner regulation or restriction on the right to vote should be immune from challenge under Section 2. And if the court were to adopt that, that would essentially make Section 2 a meaningless provision with respect to these kinds of challenges. And the plaintiffs in the case below, those defending vigorous application of Section 2 in this context, I thought did an excellent job in the briefing, did a really superb job in the oral argument, and I think exposed the flaws of that extreme position. But that having been said, of course, we're now talking about the decision being rendered by perhaps the most conservative Supreme Court in the country's history, certainly in modern American history. And there's not a lot of love for Section 2 of the Voting Rights Act among those conservative justices. And so I think everyone fears that the court's going to cut back on Section 2 here in this case. I will say from listening to Tuesday's argument that it feels to me like the most likely outcome will be a loss for those seeking to protect voting rights, but probably a narrow one. I think the ultimate effect of these provisions on the populations in Arizona was somewhat limited. It didn't have a huge disparate effect, and so it's possible the court will say you've got to show a significant effect, and this one wasn't significant enough. And there are other ways in which the court might rule narrowly against the Arizona plaintiffs, and it did seem, I will say, at oral argument, like the challenger, the anti-Section 2 side of the case, the state of Arizona, the Republican Party, backed off the more extreme version of their position in the brief. They did concede that certain kinds of steps taken by state officials, like having one polling place per 1,000 people in a white neighborhood and one polling place per 100,000 people in an African American neighborhood, would very likely violate Section 2. So I feel like it's, there's some sense in which we may see a narrow, we can hope that a narrow decision will come out, but we won't know for sure until June when we see what the court has to say, rather.
So Don, just, hearing your explanation or your discussion on that, of course, we hear about cases before the Supreme Court, and because they're not necessarily coming directly from our state or issues that we think are directly impacting us, that really is not the issue. If the court rules on this case out of Arizona, how they presented it, then that would have a far-reaching, of course, impact on all states, including Mississippi, correct?
Absolutely right. And we probably get some more insight from our friend Rob about what the particular risks in Mississippi would be. But there's no doubt about it. I mean, the risk will be not just that the decision ratifies existing restrictions on the right to vote or efforts to suppress the right to vote, but that it will be read as a green light by, for state and local officials who are inclined to try to suppress the vote through these kinds of techniques, wiping out early voting dates and making voting harder in lots of different ways. They may see the Supreme Court's decision when it comes out this summer as a green light, and that would be terribly unfortunate consequence, obviously.
And one more question, just regarding the Voting Rights Act itself. Since it became law, there's been a concerted effort to chisel away at those rights that were availed under that law. So are we, based on what may not happen after Tuesday's hearing, are we seeing the Voting Rights Act sort of disappear before our very eyes?
Well, there's a lot of concern about that very thing. I think it's why there's so much focus on the part of those who care about voting rights in Congress now to pass the John Lewis Voting Rights Act, which I think is an effort to staunch the bleeding here and restore the protection of voting rights to the paramount place that it, in my personal view, it should have in our system. And I think it will take legislation. I don't think there's any reason to think the courts now are going to push back in an aggressive way on these vote suppression efforts.
And we've moved from the Voting Rights Act, certainly important to our very citizenhood, as I would think, or citizenship. We moved to that of the Affordable Care Act, which I know that you were there, but basically from its infancy, and have argued before many of the challenges, or against the challenges that were set before the court, and you're set to do that once again. Can you tell us, share with us your I guess what you see on the horizon?
Yeah, so and that's an amazing thing, really. That before I went into the government in 2009, I really hadn't paid very much attention at all to healthcare issues or healthcare policy. But then, of course, President Obama made the Affordable Care Act, one of his very top priorities as soon as he came into office, and he fought very hard to get it enacted into law. And it was subjected to an extraordinary assault in the courts, starting on the very day that the president signed it into law in 2010, March 2010. A whole bunch of lawsuits were filed then. And I was working in the White House at the time, and part of my job was to work to coordinate with the Department of Justice on the defense of the Affordable Care Act starting in March of 2010. And now here we are, 2021, and the constitutional challenges to the Affordable Care Act there are still going, and actually argued again in the Supreme Court in November of last year in defense of the Affordable Care Act, and the sort of the third big existential challenge to the act. It was a case, of course, you remember in NFIB versus Sebelius in 2012, the court rejected the big constitutional challenge to the act at the outset in the case that I did when I was Solicitor General. And then there was another case called King against Burwell, which came along 3 years later, which was an attempt to use a certain statutory construction of the act to try to blow the act up, and the court rejected that. And we sort of thought after those two challenges that the law was in secure position, that it had survived its challenges in court. It just needed to be implemented and it could move forward. Then, of course, Donald Trump won election in 2016 and vowed to repeal the Affordable Care Act. And there was an effort in Congress to try to repeal the Affordable Care Act in 2017. And that effort failed. You probably remember the famous scene of John McCain walking onto the floor of the Senate, and when his vote was going to be the decisive vote on the repeal legislation, and giving the thumbs down, rejecting it. And so the Affordable Care Act survived that effort to repeal it. At that point, it had survived these two judicial challenges. It had survived the effort to repeal it, just barely, but it did. But later in that year, the Congress took a step that created another basis for legal challenge. The Congress eliminated the tax penalty that came with the so-called individual mandate. You remember that famously in NFIB versus Sebelius, the Supreme Court decided it would uphold the individual mandate as an exercise in Congress's tax power. Basically, the court said, well, look, Congress doesn't have the authority under the Commerce Clause to order people to purchase insurance, because that goes beyond the limits of Congress's power. But Congress does have the power to impose a tax under its taxing authority on people who don't have insurance. And that's how the court decided it would interpret the Affordable Care Act. And so there was a tax of several $100s on people who decided not to get the insurance that the law wanted you to get. In 2017, Congress zeroed that out, said that we're going to reduce the tax to zero. And that, of course, created another opportunity for these people who hate the law to jump in and try to attack it again. And that is what they did. Very soon after that legislation, they filed a lawsuit. They picked a judge in Texas, federal judge in Texas, who they thought would be sympathetic. They filed a lawsuit and said, well, now that the tax is zero, you can't defend the individual mandate anymore as an exercise in the tax power. And therefore, the mandate is unconstitutional. And guess what? If the mandate is unconstitutional, the entire rest of the Affordable Care Act has to come crashing down with it as unconstitutional as well. And the district court agreed with that argument. One of the reasons, I think, was because the Department of Justice under Trump decided that it would not defend the constitutionality of the law, and instead it jumped in and attacked the constitutionality of the law. Well, anyway, in the fall of 2018, the Democrats retook the House of Representatives, and Speaker Pelosi decided that she wanted to have the House intervene to defend the constitutionality of the law that the Department of Justice wasn't defending. And they asked me to come on board to help with that, which I did. And the case worked its way through the Fifth Circuit, where we lost, and then we did convince the Supreme Court to grant cert in the case and argued for the constitutionality of the law. And that argument took place in November. And don't want to jinx myself, and I assure everyone watching I'm knocking on wood as I say what I'm about to say, but I felt pretty good coming out of the oral argument. The court may well decide that the mandate itself can't be sustained as constitutional anymore because there's no tax consequence for failing to get insurance, you don't have to pay a tax anymore. But it sure felt like they were going to leave the whole rest of the law in place, which would be really a complete victory as far as we're concerned. Now, no guarantees, we'll see when the opinion comes out, but I felt pretty good coming out of that the law was going to survive yet another brush with death. And really is amazing when you think about it that this has been going on for more than 10 years now, and it's a law where it's become a matter of a really, really great personal importance to me. And that, more than 20 million people get health care as a result of this law, not to mention all the other good things it does, but that's a lot of Americans whose health care depends on the existence of this law. And one of the most wonderful and gratifying things for me when I was Solicitor General, the people who would come up to me and tell me their personal stories about how much of a difference the Affordable Care Act actually made in their lives. People would come and say things like, well, my sister is a breast cancer survivor and she couldn't get health insurance until the ACA. Or another person told me he had a son with a lifelong chronic condition. And he said, my wife and I, for all of our lives, were worried about what was going to happen to him when we weren't here anymore. But now we know with the Affordable Care Act that he'll always have access to affordable health care, which he's going to need to stay alive and live a fulfilling life. And so, I heard so many stories like that, and that stuff sinks in. It really helps you appreciate that this is not some abstract policy battle. This is about what really matters in people's lives.
Right. And that's Don. My work with MCJ is so connected to the everyday lives, to where I say where the rubber meets the road for definitely for poor, for marginalized people. But as a breast cancer survivor myself, I certainly was so ecstatic when the ACA passed, allowing or prohibiting pre-existing issues from being covered. I went through law school for 3 years with a lump that I refused to get diagnosed because I did not want it to be considered pre-existing.
Yeah.
So immediately after law school, it was diagnosed. So, not I would never advocate anyone to do that. And certainly under current conditions, we don't have to, but just knowing that there are people who would take extreme measures in order to survive daily. And the ACA has stood in the gap and provided coverage where many people like myself would not have had it. So I'm very
Thank you
thankful.
for sharing that. Thank you for sharing that, Vangela. I didn't know that, but now I can add another really important story to my
Yeah.
storehouse of stories. So
Right.
thank
Yeah.
you.
Yeah. And too, just thinking about not only the ACA, but of course the voting rights. That's people uh, who are marginalized or who are fighting extraordinary circumstances and issues during everyday lives of people who are going to be most impacted by potential of losing the ability to vote, losing the right to vote, and or if we cannot prevail or don't prevail on the ACA, maybe losing that as well. So it's again heightens the need for organizations like MCJ, and I appreciate your commitment. Let's talk a bit about you mentioned the former administration. Um, let's talk about your pro bono work during the 2020 election. I mentioned in the invitation that we were going to talk about
Yeah.
your protecting the integrity of the 2020 election. Tell
Yeah.
us.
So it wasn't. So just to be clear, disclaimer at the outset, it wasn't pro bono work because I was just working as a volunteer. And because you can't actually do pro bono work for political campaigns, and so because they think of it as a contribution, so it was all just purely volunteer work by me and my colleagues. But it was an amazing thing, along with Walter Dellinger, who was an MCJ honoree, as everybody knows, a couple of years back, and Seth Waxman, both former Solicitors General. The three of us formed a team pretty early on in the year 2020 because each of us in our own way was sitting at home and stewing and worrying about what we saw as unprecedented existential threats to the 2020 election. You know, it wasn't crazy to think that they might even try to postpone the election, you know, and you had a situation where, from our perspective, there was a whole lot to worry about because there's that famous phrase about Donald Trump that, people don't take him literally, but they do take him seriously, his supporters. Well, we took him both literally and seriously. Um, he said that he wanted to postpone the election. He said that uh, he would not guarantee that he would respect the results of the voting. He said hundreds and hundreds of times that he thought that mail-in voting for Democrats was going to be fraudulent voting that would be illegitimate. So we thought we had a lot to worry about. And so basically the three of us uh, brainstormed for a while and came up with a long list of ways in which the electoral process might be subverted, some by the president and the executive branch, some by state governments. And then we divided up those issues into three buckets. And I took the bucket of issues involving the abuse of the federal government's power to try to disrupt the election. And Seth took the abuse of state government's power to try to disrupt or subvert the election. And then Walter took basically the whole process of what happens after election day, getting the electoral college electors certified in the states and then having them counted on January 6th, which we now know is an important part of the process. And it was a gigantic effort and in very short order. I mean, and we after doing this kind of on our own initially, we eventually made contact with the Biden-Harris campaign and told them we were doing it, and they asked us to come aboard as volunteers and kind of work with them, just sharing our thinking with them and our preparation with them. And we did that, and starting in the summertime, we basically had a phone call with the legal leadership of the campaign every single night. I guess we took Saturdays off, so 6 nights a week we would have phone call and go through all of these doomsday scenarios with them. And we produced white papers on dozens and dozens of these potential threats, very substantial documents analyzing what legal authorities might be invoked to try some of these things, what we would do in response and how. And then we produced all these model pleadings, and it was an amazing effort. It really involved the volunteer work of hundreds of lawyers from all around the country. It just was an amazing thing to do. And the thing about it was that although you could be sort of a glass half full person and say, well, yeah, there was an unbelievable stress put on our electoral system. President Trump did try to overturn the results of the election in the key states. He did so by trying to go to the state legislatures to make it happen. He did try to subvert the process on January 6th. All those things happened, but they didn't work, and the system held. That's the glass half full way to look at it. I got to say, though, after 6 months of working at it, I'm more of a glass half empty person on this, unfortunately, because what happened over the course of this period of time, I think, was a lot of issues that Walter and Seth and I and the people working with us were able to kind of dream up on a whiteboard as hypothetical risks, which had never before materialized ever in American history, actually materialized. They didn't work, but they materialized. And, one of the big ones that we had focused on very early on, probably by August, we had figured out this was a big, huge risk, was the risk that in the key swing states, Pennsylvania, Michigan, Georgia, Arizona, Wisconsin, that the state legislature might try to step in and overturn the results in those states if Biden won those states. And the reason for that worry is that the Constitution has an electors clause and an elections clause, and basically those two clauses delegate the power under the U.S. Constitution to state legislatures to provide for the time, place, and manner of elections, and to provide for who's going to be certified as an elector in the state. Now, what every state has done in this legislature has done is say that the winner of the popular vote in the state will be certified as the elector. But with all of the rhetoric coming from Donald Trump about how mail-in balloting was going to be fraudulent, and we knew because of the pandemic that there was going to be a massive amount of mail-in balloting, and then of course you may remember in the fall before Election Day, the Department of Justice and the Attorney General Barr started chiming in on that, saying, yeah, we're really worried about fraud, and we think there's a big risk of fraud in mail-in balloting. We were really worried that a scenario was going to emerge where maybe those states were pretty close, and Trump would claim that the results were fraudulent, that the mail-in balloting was full of fraud, and that they might get back the state, and that they might get backing even from the Department of Justice on that. And then the state legislatures would use that as a pretext to step in and say, we're going to award these electors to Donald Trump, even though Biden won the popular vote. And what the heck should we do about that? How do we plan to prevent that from happening? So we were really worried about that. And it turns out they did try. That's exactly what they tried. Didn't work, but it's exactly what they tried. And then we were also worried about January 6th. Now, I will say armed insurrection is not one of the things we anticipated. We thought we had thought of every doomsday possibility we could. And we did see January 6th as a vulnerable point. We thought it was a place where the vice president has a role to play under the 12th Amendment to the Constitution and a federal statute called the Electoral Count Act, which governs what happens on January 6th. And we thought, well, no one in history had ever before thought that the vice president could turn that role from a ministerial role into a substantive role and act like a judge and declare states' votes tainted by fraud and therefore not count them. But we had anticipated that possibility and had prepared, analyzed it all out and prepared our legal defenses and had papers ready to go to court in case we needed them for that night on January 6th. And then you saw, in the run up to January 6th, several of the sort of right-wing legal scholars who were assisting the Trump campaign started writing articles and blog posts and other things saying, yeah, the vice president has the authority to step in this way. And then Donald Trump started putting enormous pressure on Vice President Pence to step in that way and overturn the results. And that was, I think, a big part of the motivation for the insurrection. Actually, was people were stirred up to try to go in there on January 6th and stop the vote count and pressure Pence into awarding the electors to Trump. Now, again, didn't happen. Didn't happen. But now, unfortunately, we know that these things have moved from the realm of the purely theoretical to the realm of the possible because they tried them. And what if the next election is, more like the election in 2000 rather than the election in 2020? I mean, in 2020, of course, part of the issue for them, for the challengers, was you had to overturn at least 3 states. You couldn't just go into one state and try to flip the result. You had to overturn at least 3 states to get to 270 electoral college votes. And that was against the backdrop of a popular vote victory by Joe Biden of more than 7 million votes nationwide. It just was, seemed just implausible. But what if it was like Florida, where it comes down to 1 state and it comes down to 500 votes? You really think that people are going to be able to resist the pressure in that scenario to subvert the results through these mechanisms? Hopefully we'll be able to resist it, and we now know how to fight it. But that risk is there and it's real. And I wish it weren't. I wish it weren't. And maybe I'll have more perspective on this with time, and maybe my concerns will abate a little bit. It's part of it is you stare into the abyss for all these months and it affects the way you think. And so maybe it'll look a little better with a few months' time. But right now, my sense of things is that there's a reason to be worried.
Yeah. And I think too, depending on what happens with the with Arizona, the voting rights ruling from the Supreme Court, it could be made a lot easier,
Of course,
particularly as
right?
it impacts mail-in voting and just challenging whether or not a vote should stand if someone delivered it for a person who's disabled. So
It's a
it,
really
it
good point. Really good point. Yep.
before I want to get to some questions from our audience. Of course, I have about 15 others myself, but I do want to ask one question before I start checking the chat box for questions from our audience. And I guess that has to do with, you mentioned, of course, COVID. We know that we've all dealt with unprecedented challenges presented by COVID. In the court, Supreme Court, I just know can't be any different. What challenges or what changes have you dealt with in arguing before the court during the pandemic? And has that presented any particularly heightened challenges in your argument or your presentation?
Yeah, it's funny you'd ask that. I think, as everybody knows, the court has, of course, gone virtual, like everyone else has during COVID. But most courts of appeals, federal courts of appeals, and even federal district courts and state courts have gone to formats like this, Zoom type formats for arguments where you got video, and then they live stream it often. The Supreme Court didn't do that. I mean, I think they're still steadfastly opposed to any idea that there's going to be video, video transmission of a Supreme Court argument. So they went to the telephone instead. Basically, you do the argument on a telephone via a conference call. And normally, as everybody knows, in an argument, a live argument in the court, it's a lot of rapid fire with the justices coming in from all angles all the time, interrupting each other and interrupting you as an advocate. And it's a very, it's really interesting. It's a very, the process is very strategic in nature, in the sense that the justices they're not just asking you questions because they're interested in what your answer is, or they're trying to puzzle their way through what they think is a hard legal issue. They're asking you questions to try to influence the outcome of the case by getting you to say things that will either attract their other colleagues to your position if the justices are on your side, or repel their colleagues away from your position if the justice is against you. And so the really intense strategic element to the oral argument process when it's live. But that's not the way it happens on the telephone. It's on the telephone. I mean, there's a little bit of it, but it's different in that it's a very orderly process. It needs to be, I think, because otherwise they just couldn't manage it. And so each advocate is given 2 minutes to give an uninterrupted opening, and then each justice, in order of seniority, gets 2 or 3 minutes to ask you questions, and they just go in order. And I will say for myself, I found it way easier than arguing live. And in part, I suppose I shouldn't say this because it'll, maybe I'll get back to them, but if you're on the telephone, someone asks you a question, if you're on the telephone, I realized pretty quickly, if one just keeps talking, it's hard for them to interrupt. And so I found that if I just got some momentum going in response to a question and just started talking and saying what I wanted to say in order to try to advance my case, and I just didn't take a breather, I just kept talking, that it was hard for them to interrupt. And I felt like I got a lot more across during my time to answer questions than I would if it were live. And so that was part, I think, just because it's hard to interrupt on telephone, part because other justices can't jump in and cut you off and interrupt you. And so I just found the whole thing a whole lot easier to manage than being live. I mean, I missed the challenge of doing it live, of course, but it was a whole lot easier to manage, I thought.
Well, you've probably given away your strategy on that, so you can when you're back, and if you're still having to do it telephonically, you can imagine that probably.
Yeah, I suspect I'll be interrupted more frequently. Yeah.
I have a question. Well, first of all, I want you to know that Walter Dellinger was he's listening to us.
Oh, good.
he's enjoying a bike ride. Nice weather. So just
Good.
getting that out there.
Hey, Walter.
Thanks, Walter, for joining us. I have a question from John Hobby, who he says he's interested in your inkling about why Trump and his enablers, including almost all of the Republican Congress, wanted to upend each and every Obama policy.
Well, each and every Obama, well, they did, they did. And, who knows exactly why. And, the thing I was involved in mostly was, of course, the Affordable Care Act issues. With respect to the Affordable Care Act, I guess I think it was a combination of things. Part, I do think, people, this is not original to me by any means, of course, but I do think that part of it was that Donald Trump seemed to have an obsession with erasing every aspect of Barack Obama's legacy that he could try to erase. And the Affordable Care Act was a really important part of that legacy. And so I think Trump was obsessed with trying to erase it, get rid of it. But another part of it, I don't think it was just that with the Affordable Care Act. Starting in 2010, it became like almost a religious conviction among Republicans that this law was evil and it needed to be wiped off the books. And I always found that a little mystifying because the law seeks to achieve a progressive aim of ensuring that healthcare is a right and not just a privilege, and that your economic standing in life doesn't dictate your ability to get healthcare, and that healthcare is really important to living a full life. But it uses, those are all progressive aims, but the main part of the law, the mandate and the insurance reforms and all that, those are actually pretty conservative by nature. That's why the more progressive wing of the Democratic Party has always wanted single payer. They'd want, basically Medicare for all. But what this system did was build on the existing private insurance system and keep that private insurance system in place. Didn't interfere in any major way with the employer coverage that most Americans get. And for the Americans who didn't get health care through their employer, that there was an opportunity to buy it from private health care, for private insurance companies on these exchanges. And it was, modeled on a proposal that Mitt Romney had enacted into law on the state level in Massachusetts, and that, tracing back to the 1990s, was actually incubated in the Heritage Foundation. And so why they decided that this was the absolute ultimate bête noire that they had to get rid of, it just was mystifying to me. But it did become like it was the thing they cared about the most, was getting rid of the Affordable Care Act. And that continued. After Trump won, they thought they could get rid of it legislatively, and then that didn't work. So they then kept up their judicial challenges. And I hope if this case comes out well that this will be it, but there's no reason to think it will be, given everything that's gone before. So it was more than just personal stuff. I mean, I do think it was a real ideological commitment on their part.
Well, I have another question from one of our viewers, Bonnie Allen, Executive Director of the Chicago Lawyers Committee. How optimistic are you about the likelihood of federal legislation to strengthen the Voting Rights Act?
I don't know. I'm no expert on this by any means. It's clearly going to pass the House of Representatives. And then, I think the question in the Senate is going to come down to whether they decide that they're going to get rid of the filibuster in order to ensure that they can enact this legislation. And I don't know what's going to happen on that. I don't know. I guess my guess will be this. Look, I'm the farthest thing from a political pundit, so you should not take this with any, put any real stock in what I'm about to say. But just seems to me that that's not going to happen in the next couple of months. I think the focus is going to be on getting the COVID relief bill enacted into law and getting the economy back on its feet and getting people vaccinated and getting life back to normal. And then I think probably there'll be an effort to do some kind of an infrastructure plan that again will garner bipartisan support. But eventually this is going to come up. And I think it's, when this comes up, I think it's going to bring to a head the question of the filibuster. And I don't know. I wouldn't say I'm pessimistic about it, but I don't think there's any reason to be unduly optimistic about it either. I think there's reason for hope, but I think it's going to be hard.
Right. And I have a follow-up question, I guess, to sort of ask us to extend that hope from Walter Boone, Chair of the Board of Directors for Mississippi Center for Justice, who asked, with the now solid conservative majority in the U.S. Supreme Court, what civil rights issues do you see as the most vulnerable, the VRA or the right to choose?
So I don't think that's an either or, unfortunately. I guess my sense of things is that with respect to the Voting Rights Act, I think they're going to cut it back. Hopefully, in this case, they won't cut it back too much, but I think they're going to cut it back, and that'll be terrible. With respect to the right to choose, I am unfortunately quite pessimistic about that. I think my own sense is that it's only a matter of time before Roe against Wade gets overruled. That now the vast majority of people disagree with me. They think that the conservative justices won't want to take that on, and they'll find ways to whittle away at the protection of the right to choose without actually overturning Roe. But I don't see how that's going to work, because a number of states, as people on this in this conversation know, a number of states have enacted fetal heartbeat laws, South Carolina most recently. And, I think there are 10, 11 states with fetal heartbeat laws, and the lower courts always declare them unconstitutional under Roe because they are unconstitutional under Roe. But eventually the Supreme Court's going to have to review one of those cases, I think. And when it does, I would be shocked if the court strikes the statute down. I think the fetal heartbeat law, when it gets to this Supreme Court, will be upheld. And at that point, there's no more Roe against Wade. And so, and partly it's because the Chief Justice, I think the Chief Justice himself, if he had to make a choice about whether to overrule Roe or not, I mean, if the case left him with no option but to say yes or no to that, I think he would vote to overrule it. We know for sure that Justice Alito would, and Justice Thomas would. Pretty likely that Justice Gorsuch would, and I think pretty likely that Justice Barrett would, and that Justice Kavanaugh would. And so I just, you don't know for sure until it comes up, but and particular circumstances in which it comes up could affect how it gets resolved. But my sense is that you got to gird yourself for the worst on that. And then, the other areas I think to be really worried about are, for example, affirmative action in higher education. I think that's I argued the Fisher versus University of Texas case twice when I was SG, and both times we basically escaped by the skin of our teeth, and so but the court's differently composed now. Justice Kennedy's gone, and Justice Ginsburg is gone, and the justices replacing them, I think, are going to have different view about that. The one place I think I feel less concerned is constitutional protection for marriage equality and for the rights of gay and lesbian people generally. I don't see the court going back on that. I think that probably there'll be a continuation of this view of very expansive religious exemptions to laws that are designed to protect people against discrimination based on sexual orientation or sexual identity. But and that to me would not be a great development. But I don't think the underlying right itself is I don't think they're gonna go back on that. But in general, there's a lot to worry about.
With that 6-3 split, a lot hangs in the balance.
That's for sure.
We have one more question before I invite Rob McDuff to join us so that he can share a little bit about some about what we are foreseeing or what's on the horizon in our impact litigation campaign for MCJ. So first to my question and then to Rob. In Jim Warren, one of our viewers asked, in the Arizona case, the statement made by the GOP lawyer about seeking an electoral advantage got a lot of press. Do you think it mattered to the court?
Yeah, maybe. So what happened there was that Justice Barrett asked the lawyer for the Republican Party, what standing do you have to be in court? How are you harmed by the enforcement of these rules? And what the lawyer said was, well, we're harmed because politics is a zero-sum game. And if fewer of these people vote for Democrats, that helps us. And it sort of laid bare, I thought, that answer kind of laid bare. Obviously the lawyer made a calculated judgment that that was the answer he was going to give, and he thinks it's strategically the best answer to give. And I haven't tried to sort of game it all out in my own head, but sort of made pretty clear what the deal was, that we want fewer people to vote. and I want fewer people to vote because the fewer people vote, the fewer votes Democrats are going to get. I mean, he basically said that. And one never knows about these things, but it does seem to me that makes it more the political effect of a ruling cutting back on Section 2 will be more salient as a result, and that could, as part of the overall atmospherics of the decision, make the justices think, well, we got to be more circumspect here. We got to act more narrowly rather than more broadly, because it'll be seen as so aggressively political. But time will tell. We'll see in June.
Well, we'll be here, and we know that you'll be our eyes and ears and keep us well abreast. So we're not necessarily looking forward to any of the outcomes that would be adverse, certainly to our stakeholders, but we know that decisions will have to be made, and then we will have to respond accordingly. I'm going to move to Rob before we close out, Don, and thank you so much for getting us through this morning and for making us just more aware of what's going on before the court and through your experiences. Rob, good morning.
Good morning, Vangela. Good morning, Don.
Hey, Rob, how are you?
Fine, thank you.
Great. Well, thanks for joining us, Rob. I wanted to ask you, I'm director of our George Wiley Impact Litigation Initiative. I know that you've worked with Don on a number of important cases for MCJ. And I'd like for you to just talk to us briefly about impact litigation and some of the important work that we're currently undertaking, as well as some of the cases that you see on the horizon.
Sure, and Don has been toiling in the vineyard in Mississippi since early in his legal career, when he handled some death penalty cases here, and that's how I met him. And we're so grateful he continues to do so to this day, including the felon disfranchisement appeal that you mentioned earlier, Vangela. And we also, speaking of cases in front of the Supreme Court, we have a fetal heartbeat law in Mississippi as well, and we were co-counsel with the Center for Reproductive Rights in a successful challenge to that bill. That is one of the many fetal heartbeat cases before the Supreme Court right now. We may have more efforts in Mississippi to restrict the right to vote, but you mentioned, for example, laws around the country cutting back on early voting. We do not have any cutbacks on early voting in Mississippi because we don't have any early voting in Mississippi, unfortunately. And we have a very, very narrow absentee law. But I think your warning, Don, about the potential impact of this Arizona case is one everyone needs to take to heart, including us here in Mississippi, because the legislature could, in future sessions, try to cut back on the right to vote even more than is already the case. In the impact litigation project, we have a number of pots that are stirring. Many of you may have read that we did receive an award of compensation for Curtis Flowers for 23 years at prison, which is the maximum money that the state of Mississippi will provide, which is $500,000 spread over 10 years at $50,000 a year, which of course is not nearly enough money in a situation like this, and is less than many states do pay. I have been asked, is there any way to get more money for Curtis? And we are evaluating the option of a lawsuit for federal civil rights violations. The problem being that the prosecutor, Doug Evans, who was the big driving force in this relentless crusade against Curtis, does have immunity for his acts as a prosecutor. So we are evaluating that option, and we'll see what happens. We are going to file a bar complaint against Doug Evans, which includes not only his transgressions during the course of the case, but the lies that he told to 60 Minutes for its episode when he claimed, for example, that there was a witness who saw Curtis enter the furniture store that morning. Now, this witness was never presented in any of the 6 trials. It's just a figment of his after the fact imagination. And so you'll be hearing more about that. We are investigating a prison death just a few days ago at Parchman in Mississippi under very problematic circumstances. That we're going to look into, and if evidence supports our concerns, we may be filing a lawsuit over that. We are in court representing the investigative reporters at the Marshall Project in their effort to recover Public Records Act as part of an investigation into private prison corruption in Mississippi. We are continuing to monitor the MOU we reached with the Department of Corrections over COVID prevention and mitigation. Of course, we're hoping the vaccine is going to get to the prisoners very soon. We are in a case reminiscent of the 1960s, when the state of Mississippi was attacking liberal professors at the University of Mississippi. We are representing a University of Mississippi professor who was falsely accused by the state auditor of violating the state's anti-public strike statute by public employees, because he participated in a national scholars event designed to call attention to racism and injustice. We are looking at possible options for workers in the Mississippi Delta who have been cheated because employers are being allowed to bring in foreign workers under visa programs at lower wages than federal law requires, when in requiring that employers first offer the jobs to domestic workers at the prevailing wage rate. Those laws are not being enforced. Employers are getting away with paying less money than they should pay because they're able to bring in foreign workers under these visa programs. And we are gearing up for redistricting around the state and legislature and the various county board of supervisors, various city councils after the 2020 census data comes out in the near future. So those are some of the things on the horizon, and we'll be keeping you all posted on all of that.
Very good. Thank you so much, Rob. It never ceases to amaze me, just the depth and the breadth of what we handle in impact litigation. And so I feel so privileged as I'm looking at my monitor. I have Don on one side and I have Rob on the other, and I am just thrilled to be here amongst the both of you and to know the work that you've done, your exemplary careers. And so thank you both for all that you've done and all that you continue to do, particularly for the people in Mississippi. So thank you, Don, and thank you, Rob. Thank you also to everyone who joined us. I hope each and every one of you enjoyed the conversation with Don and hearing our update from Rob. And if you are still unfamiliar with MCJ and our work, you can find out more about MCJ by visiting our website at www.mcj.org. mscenterforjustice.org. So I invite you to learn more, to learn more about joining us as pro bono partners and how you can support our extraordinary work, the work that we're doing every day in Mississippi to bring sustainable change, supporting the advancement of racial, economic, and social justice in Mississippi. The challenges that we face sometimes seem insurmountable, but they are conquerable with passion, hard work, and with resources. Our efforts, past, present, and future, simply would not be possible without the support of our wonderful donors and our pro bono partners, like you, many of our viewers, and Don Verrilli, Latham and Watkins, Hogan and Lovells, Foreman and Watkins, the Lawyers Committee under the Civil Rights, and Walter Krause, as well as Aiken Gump. So we are tremendously appreciative of the work and the support that we receive from those supporting our efforts to bring change. Again, at our website, you can learn how to become a part of the legal community that we work with around the country. And as you can see, we are very fortunate to have a star lineup of some of the best legal minds around, and we would love for you all to partner or to be a part of the advancement of racial, economic, and social justice in Mississippi. As you all know, as well as I do, that the law can be a very, very powerful tool for making change. And we'd love to find ways to partner with you to address the many inequities that are still plaguing our state. So we have a place for you here at MCJ. Finally, we are so grateful again to each and every one of you for joining us, to Don Verrilli for taking time out of his day, and to Rob McDuff. Thank you both again so much. And we hope that each of you found this event helpful and informative, and inspiring. I am inspired by the fact that Don and Rob can continue to do the work that they do at the level that they are providing to each and every one of us. So thank you all. And we hope to see you all again soon. So I wish you all each a very wonderful day, and see you at our next conversation.